Thank you very much, Haroon, and once again, welcome everyone. My name is Anna Strzykala. First of all, Haroon, Zara, thank you for having me today, for inviting me for this webinar. I'm an appointed data protection officer for Computershare. I'm not sure whether you've heard about Computershare. We are a global market leader in transfer agency and share registration holds. I also head of privacy for Continental Europe and Computershare, so I support my colleagues in many different aspects of privacy throughout the Continental Europe. I'm certified data protection officer by the German Data Protection and Data Privacy Association. I also hold some certificates by the IAPP, certified information privacy professional for Europe, and a certified information manager. Now, I've been supporting my colleagues in many different aspects of data protection, as I said, but my main focus lies on cross-border data transfers, marketing, and employee data protection. Therefore, e-commerce, I think, will join all the dots. And once again, thank you for inviting me, and over to you, Zara.
Thanks, Anna. I'm Zara Shah. I'm the co-founder, non-executive director, and investor at Seers. I'm also an expert member of the ICO's Technology Advisory Panel, and I also serve on the board of a venture capital fund and another fintech venture. My background is in fintech and regtech at Accenture for over a decade, where I helped global investment banking clients on helping them comply with various regulatory requirements through the application of cutting-edge fintech and regtech solutions. And I hope that today we can have a fruitful discussion where we can help answer some of your concerns about privacy compliance.
Shall we start by answering this, global question that's been asked so many times? What's the difference between UK GDPR and EU GDPR now, since after the Brexit?
Well, the GDPR in domestic UK law is so-called the UK GDPR, and first of all, and foremost, UK still has enjoys the adequacy decision of the European Commission. That means that there's an adequate level of data protection in the UK, and it reflects the data protection level in the EU. Therefore, there is no need for SCCs. And the UK, even though we already are facing Brexit, is not treated as a third country when it comes to data protection, and there's still a free flow of data transfers between UK and the EU. So there are some, the key principles of the UK GDPR remain the same, exactly the same as in the EU GDPR, so to say. However, for those who face on a daily basis data transfers between those two regions, there is no need to worry for at least the next 3 years, and after that there will be a revision of the adequacy decision. And in the meantime, the privacy law in the UK is still being monitored by the European Commission, so the decision will come. Perhaps we will face a Brexit and data protection. I hope not. And I hope we won't face a situation where we have a transatlantic data privacy agreement between the US and the EU, but we don't have one with the UK. That will be terrible. So, but it's a case.
That's great. So there isn't much difference, right? So what is the GDPR checklist? What is it that every website should have to comply with GDPR?
To comply with the GDPR, the compliance with the GDPR is actually compliance with a couple of main principles which are listed in Article 5 of the GDPR. So the data that is being processed has to be processed lawfully. There always have to be a legal basis for it. There has to be fairness and transparency of data processing. Of course, there has to be purpose limitation. Therefore, it means that we do not process data for any other purposes than those it was collected for. Data minimization means data should be processed only in absolutely minimum. So we do not collect more data than we actually need to fulfill the purpose of processing. Accuracy. So we ask only for that what's absolutely necessary. and storage. We do not spread the data. We do not copy the data within the organization. We store it at a given place, which is properly secured by technical organizational measures, which I will refer to later on, perhaps, as we speak about data security. There always have to be a set of appropriate technical organizational measures which will guarantee the integrity of data, confidentiality, and availability. So those are the principles. Now, how does it look actually in the real life? You've seen many thousands, I guess, of different cookie banners on different websites. This is the first point of contact between you and your client, you and the user. So the moment that someone enters your website and sees the banner, it has to be construed in such a way that it will provide all those principles. It will inform in a simple and transparent way what data is being processed, for what purpose, for how long it's going to be stored, and how a data subject can exercise their privacy rights, the right to deletion, access, or correction of their data. And we achieve a point where we can comply with those requirements. I think we've done a lot of good work, something that is not unfortunately often to be seen on many websites. Therefore, a right cookie banner, a transparent and compliant with the GDPR cookie banner, is the first very important step in the customer's journey or the user's journey.
Great, thank you, Anna. Zara, so in simple terms, we know it's a cookie consent management platform that a website should have as the first instance a visitor appears to get consent. What differentiates a compliant cookie consent from a non-compliant cookie consent?
That's a very good question, Haroon. I think I will put it in very simple terms for people to understand. There are three things that you require in order to have a fully compliant consent management banner. The first thing is that it should have, in order to have explicit prior consent, you should have three options: accept, reject, or set preferences. And whenever you see banners that already have a tick box, which says accept all, or it's all okay, or I accept all essential cookies, that is not compliant. So you must have the option to be able to look through all the different types of cookies. When you click on preferences, you should have a table that lists the different types of cookies or third-party technologies, tracking technologies that particular website is currently kind of involved in, and then also give you the option to select the ones you want to enable and the ones that are disabled. And we would only recommend, as Anna has explained from a legal point of view, generally you should only select essential cookies because it helps to enable you to browse a website. But for certain specific functions, you might also need the other more advanced cookies. But as long as you understand the different types of cookies, the purposes, only then must you go and accept it. Because the danger of not doing that is that your personal information then is easily stored, harvested. It's maybe shared with in ways that are not suitable. You might be targeted by different advertising companies. So this is something that you really have to be very careful about.
Essential cookies are those cookies which are belong to the only exception where you do not need a consent. And the mistake that often happens on many websites is that you visit the website, you see the banner, and there is a pre-ticked box, essential cookies, and it gives this impression that the user is given consent for essential cookies to be used. And this is false. The wrong legal basis for data processing. It's not the consent that allows you to place essential cookies on the end user's device. It is your legitimate interest. So it will be Article 6, paragraph F, and not A. Therefore, it is important always to give, as Sarah said, the user a transparent overview of non-essential cookies, and to let them decide which cookies would they like to place, or let them be placed on their device. And by doing so, not only the list of the cookies like we use tracking cookies, those cookies have to be listed out with the name, the duration, and the functionality, so that whenever the user would like to choose to check their end device, what kind of cookies do they actually have stored on it? Not many do so because not many know how, and there's no need for that. But still, if they would like to check it, it will have to be compliant with what they have been presented on the website, on the cookie banner. So the moment that this one out, which is surprisingly enough not very easy for an organization to figure out, do we use cookies? But cookies is not everything. There are many other tracking possibilities. There are pixels, there are KPI, there are this is device fingerprinting, which also enables tracking because it enables to define to identify the user, and it has to be everything has to be presented in a very transparent and easy accessible privacy notice. So as soon as the website has that already and does not use nudging, which is another important aspect, do not let your advertisement agency to place a cookie banner where they say accept all, and is somewhere in small print on the bottom of the of the banner, not easy to see. It's not fair and it's not legal.
A lot of people sometimes put their marketing cookies or their third-party cookies into necessary cookies. And sometimes people even also have an argument that we only have one or two cookies, so we don't need it. So what are the consequences, Anna?
This is an unlawful processing. The moment you place a cookie on the end user's device, you're violating not only the GDPR when it comes to lawfulness of data processing, but also the Privacy Directive, which states very clearly that the moment you read out any information placed on the end user's device, or you place any kind of cookie in that case on the end user's device or other IT solution, that unless these are absolutely necessary to deliver a service that this user requested by visiting the website, you have to have their consent. And by having consent, it means that you have to be able to demonstrate that you have collected the consent. And this is where we go back to the, as Sarah already described, compliant cookie banner. A right consent management system will allow you to demonstrate that you've collected the end user's consent. And this is another aspect that's sometimes being neglected. And another thing which is very shady, and sometimes the advertising agencies advise that as a solution, is to put a third-party cookie as a first-party cookie. So then the organization say, hey, we don't use any third-party cookies, and the end users thinks, okay, so I'm safe. But at the end of the day, it turns out that put the third-party cookies as first-party cookies. So they put tracking cookies on the website themselves, and they still track the behavior of the user on the website without informing them of doing so, which is also a violation. Most serious violations, as you already know, as you're a specialist in that kind of consent management, and that violates Article 5, which is article containing all the principle of lawful data processing. So any violation of that article has serious consequences, financially, and not always only financially. It's a bad publicity that the organization has to face.
So Zara, my next question is this could be an exercise to gain customers' trust?
I think for any company, but particularly a digital organization, the most important thing is your brand, which is basically based upon the customers trusting you and holding you in as a credible organization. So once you lose that trust, it's very difficult to get that back. If you do your best to build that trust, then not only will you gain more customers, but you will also it help you retain your customers, and not just customers. It's your partners, your suppliers, your employees, because trust is the most important, I would say, success factor for a digital organization. And what GDPR does as a privacy, I would say it is one of the key privacy regulation, across Europe, and it has become the benchmark globally, where other countries are basing their privacy regulations on the GDPR because it's so well respected. And since the pandemic, since there's been a huge shift to remote working, there has been a doubling of data breaches and cyber breaches, which has actually broken a lot of trust for people. They feel nervous about, you know, transacting with e-commerce companies because of the risk of cyber breaches. It's even more important for companies to ensure that customers are satisfied that their private and personal information is utilized only as they have given their consent, and also that it is very it is clarified to the customers, because in some of the organizations, as we just discussed, it's not very clear, so customers are very confused. They think that they're consenting to something which is actually completely different. Misleading customers breaks trust, you know, it affects your reputation. So yes, ensuring compliance will not just help you protect you from fines or reputational damage, but actually it helps your business, and it will impact your rate of return in the long term when you are able to retain and gain more recurring customers.
Absolutely. So the first and most important part is to make sure you don't drop any cookies. All scripts are blocked the moment somebody uses or enters your website for the first time, of course, because after they make their decision, the system will recognize the user again. And so the scripts are blocked. There are no cookies, no pixels, nothing, absolutely nothing. And at that stage, the user sees the banner. And at that stage, this user has the opportunity to make a decision: accept all, reject all, leave me alone, or to see the very transparent, easy, available, accessible privacy policy, a privacy notice, not policy. I was the one to say it's not policy, it wasn't I. So apart from the cookie banner, there has to be possibility to see the privacy notice. And now in the privacy notice, the website owner or the online shop owner, whoever it is providing their all the information around data processing. And if there's a direct if they are collecting the data directly from the data subject, it's based on Article 13 of the GDPR. These are information obligations. And in those terms, privacy notice informs very, very transparent, it should inform in a very transparent way, what kind of categories of personal data are being collected by this website, for what purpose, has access to it, whether there is a transfer to a third country, if so, whether the organization already secured the transfer by signing SECs or accepting their binding corporate rules, which are two most common ways to regulate the data transfer to a third country, how long the data is being stored, and what are it's a very important part. In Germany, it's even a requirement to put this information separately from all other information in the privacy notice, how the data subject can exercise their privacy rights. So is there an email address? Is there a contact form? How they can contact the website owner in order to request their deletion of the data, correction, and or simply access to the data, which brings me again to transparency and again to a very big importance of consent management tool. Those consent management tools are not only provide to just follow on the consent process, whether somebody's given a consent or not. It's also provided for you, for an organization to be able to process the data in the transparent way, in order to be able to track the data, in order to be able to maintain the correct data mapping. And that, together with identifying applicable laws, I think those are two main important steps whenever somebody is going online. First, figure out whether you know where your data is going, how you're storing it, whether you can access it, whether you can fulfill those requirements that I mentioned at the very beginning, Article 5 and 32, of the GDPR. And then have a look at whether it's only the GDPR. I mean, the GDPR is, of course, as Sarah already described, an extremely important instrument, one of the most important instruments for providing lawful or securing lawful data processing and guarding data privacy and protection. In the GDPR alone, in Article 2, in the material scope, in paragraph 4, there is already mention of this regulation being applicable, but without prejudice to the application of the Directive 2031 of the European Commission. That's the directive on e-commerce, which been amended recently by the regulation. I think it was adopted on the 27th of October. It's going to enter into force after 20 days. It's the regulation 2022/2065, single market for digital services. Something to be aware of, something to track, especially that it's not a directive which has to in the EU, we have secondary and first-tier law, so there are directives and there are regulations. When it comes to directive has to be implemented. So it means all the member states have to find the right methods and tools to implement everything what is required by the directive. Regulation, however, enters into force one-to-one, exactly in this form and under these conditions which are stipulated in this document. And this is the regulation we are talking about. It's going to enter into force mid-November, I guess. So it's worthwhile to have a look at it, because there are other documents and other lawful instruments which are applicable for e-commerce, and so not only the GDPR. If you have a look at Article 2, you can start your journey.
Is there any other policies that you believe that they should implement, not on just the online website front, but in the organization side as well?
That's a very good question. I think the whole issue of privacy and security should be a matter for the board of a company and the C-suite. For an effective and successful e-commerce business, they need to look at the whole they should come up with a whole privacy framework, a strategy for the organization, that this is what we need to do in different areas of the business. You know, a website is just the basic, because that's your initial channel with your online customers. That's your first impression. But beyond that, you should be looking at all the various processes and procedures that are currently taking place in your organization to make sure that you have the checks and balances in place. And it's a very good, I would say, it's good practice from a governance point of view, from an ESG point of view, to actually do an audit of your whole organization. I would suggest doing actually a privacy audit of your organization to figure out the flow of the data across the organization, how it's used, how it's stored, who are the end users. And once that will actually help the organization in terms of identifying where any gaps are in terms of the digital processing as well. It will help them in terms of producing more detailed analysis as well, that will help them gain some customer insights, which will help the organization to address the actual needs and wants of customers instead of what they think the customer wants. So actually there are a lot of benefits to doing this exercise, not just for compliance purposes, but actually for commercial benefit, for business benefit. And I would say, in terms of your organizational strategy, the technology and privacy strategy should be a very important part of your strategy if you haven't actually looked into it already. And apart from looking at the privacy policies, when you drill down into the data, then you look at all the different processes, you might also find out, if certain processes are not effective anymore. So you might actually end up re-engineering processes as well. From the compliance point of view, things that you should look into is to also, if there is a breach, if there's a customer complaint, if there's a customer request for information, which is called the data subject access request, what sort of a position are you in to be able to respond to that? So once you have data, I would say, almost kind of doing a little bit of a data discovery within your organization. And once you have a proper strategy, then you can respond very quickly to the subject access requests as well. And the other thing I think organizations should take into account is whenever you're starting on or embarking on a high-risk venture or high-risk project, you should also then look into undertaking a data impact assessment as well. So you are assessing the risks of, in case there are, in the case of recently in parts of the world, we've had a lot of climate disasters, for instance. What we call the black swans with the war in Ukraine, and then in the UK we have Brexit. So we have all of these unknown factors coming in. So you need to be able to take into account when you're doing a risk analysis the impact on your information, your data, and your customers, suppliers, and your employees as a whole as well.
I absolutely agree. And another part is data breach management. So whenever you have to be able to identify anything that does not fall into the normal business as usual processes. Under those processes, you have to be able to you have to have your incident management. So whenever something is runs not as usual, it should run, to be able to identify whether it's only an incident or whether it's a data breach, whether it should be reported, whether you should inform not only the supervising authority but also data subjects whenever you're collecting their data directly from them. And as a processor, then you have to inform your controller. A very important part as well. Well, this is everything boils down to transparency and what Sarah already mentioned.
We also think of even data retention policy, because you have a lot of data, right?
Of course. Without data retention policy, you're not able to fulfill your informational obligation and to inform the data subjects how long are you going to store their data if you don't know yourself. So the moment you create, not to collect your data, but the moment you create a process, you have to take into account, as Sarah mentioned, a risk assessment and the ways and means of mitigating those risks according to Article 35. If there are no special risks, then when you're fine with your preliminary so-called threshold analysis, which is a preliminary risk assessment. Even if you have a process that requires privacy impact assessment, then of course you'll have to check whether the data retention periods are in place. It means whether you've identified them. Oftentimes their accounts and you're storing their data, and then they come in, they have the CAR and they say, I'd like to have my data deleted, please. But you cannot delete them because you're obliged to retain data, depending on the country, for far longer than the data subject requested, for 2, sometimes 10 years, in order to fulfill your requirements and your obligation arising from other legal acts. And this is where the legal basis for data processing and the purpose of processing is changing. And this is what has to be reflected in the records of processing activities pursuant to Article 30 of the GDPR. But this article is very transparent about the requirements, so it's easy to follow.
A lot of data is there for remarketing, and you pass it on to a trainee, and that gets lost. What are the consequences for something like that?
Well, a trainee is as big a threat to the organization as a hacker, because during the training periods they acquire access to all the systems because they have to, even though there are simple things that they do, but they have to get acquainted with the processes. And at the end of the day, oftentimes the organization neglect, they don't have the right internal processes in place in order to withdraw those access rights. And at the end of the training period, this person knows absolutely everything about the organization and can pose a great threat and risk to data security. In the security, I mean data confidentiality, integrity, accessibility. There are a lot of things that can happen. So this is a process that has to be followed. The trainee has to be followed. The moment they acquire new access rights, new logins, they have to be deprived of the previous ones. Again, a task for, as Sarah mentioned, C-level management. and a privacy team as well, in order to provide the right policies and to define the processes together with IT team, which oftentimes exercise those rights and can grant access to systems or deny those.
Zara, do you think that trainee should be trained with GDPR? We'll ask Anna if there's a legal obligation for it. But what's your thoughts on that?
Definitely, not just your trainees, but all staff members should be regularly trained in understanding what their responsibilities are under the privacy regulation, because a lot of these data breaches that have occurred recently are due to human error, or if people do happen to make mistake, they will know exactly what process to follow. They will be able to identify and rectify that mistake very quickly. So definitely trainees should be trained as well, so that they don't by mistake don't actually give some information or misuse some information or delete some information that could lead to major disasters like the data breach.
Anna, so is this a legal obligation for the staff to be GDPR trained?
Yes, training and awareness, it's something that belongs to the list of long list of technical organizational measures that a controller or processor has to have in place. It has to be, this organization has to be able to demonstrate that their employees have undergone training, and it has to be also carried out in a way of a process and a plan, form of awareness strategy, whether it will be phishing campaign within the company, which is very surprisingly bringing some astonishing results. Some people cannot recognize phishing emails from the original emails, which is our training itself. These are steps that have to be taken apart from IT security, meaning IT infrastructure in form of software solution, due to the fact that the human error plays such an important role in risk, not only assessment but mitigation. It can on an organization very badly. So a good training, awareness, by raising awareness is simply signalizing, hey, have you blocked your screen the moment you left, or whether it was the system that had to do it because you've forgotten, or phishing campaign, as I mentioned. Those are simple steps, but they go a long way.
Brilliant. Thanks, Anna. Actually, thinking about the checklist again, so we got the consent management platform, we got our privacy noise, we got all the required policies depending on your internal operations, a GDPR audit, and then obviously training your staff with the fundamentals of GDPR so they can minimize, secure, delete any private data that they actually acquire or control or process. Zara, is it worth for a company? I know a lot of people will be thinking like, we have to buy the solution, or I have to spend enough time to create these policies. Is it worth it to be GDPR compliant?
Definitely. It will, the work that the organization does in actually ensuring that they are GDPR compliant, by doing the analysis, doing the audit, putting the policies and procedures in place, making sure the consent management platform is compliant, that will actually help them in ways that will help them increase revenue over the long term. Firstly, it will create confidence and trust within the customers. That will not only help you retain your existing customers, but you will be able to gain new customers quickly because they will trust you. Secondly, you will also be able to respond very quickly to changing market conditions, because you will know and understand what information you hold, how that information can be leveraged as well. So you'll be able to respond quickly. Thirdly, you'll be able to develop customer insights. So you'll understand what are the real requirements and needs of the customers, and be able to develop, other additional services or features in your existing services to be able to respond to those, to be able to meet those needs. Because a lot of e-commerce businesses are still focusing on what they think the customer needs or the customer wants. Because these needs and wants can change, especially now since the pandemic. Things have changed dramatically, and companies need to companies feel a little bit behind in understanding the changing needs of customers and being able to meet those needs. So the whole data analysis exercise will help companies do that. And also the data analysis exercise will help you define, where your future growth areas are. You could do a more in-depth, a well-informed risk analysis, forecasting exercise to figure out, what are the areas you need to focus on in order to grow successfully, or markets you need to focus on. So it will help you in your long-term growth of the company as well. So I would say overall, there's a lot of commercial benefit to the company that will actually help them increase their revenue over the long term which is very interesting, because the various requirements of this regulation are actually very common sense in terms of some of the best practices a business should be undertaking in any case. So if businesses have perhaps been a little bit lax in that area, this gives them the opportunity to go ahead and ensure that those their business strategy, those processes are actually very effective. For listed companies, if you are in a breach, you could actually affects the share price. The damage is not the reputational risk or just the fine itself, which is huge, 4% of your annual global turnover, but the share price, which is even worse than any fine. So for listed companies, it's even more important to comply, and in a lot of cases, the governance requirements also helps you meet the ESG requirements as well, which is also a key requirement now for listed companies, the ESG index. So it helps you develop kind of an overarching view of governance, I would say, across the organization.
Thanks, Zara. We will take the questions now, and if any of the attendees want to ask any questions, please feel free to write in the question section. Why do some companies choose not to have either a cookie banner or a transparent cookie policy?
Because they think they're under the radar and nobody will notice it. And even if somebody notices it and informs the supervising authority, nobody will bother to pursue it. Then there is a cost factor. They think it's cost too much. Even they don't trouble themselves to do some research and to post. Even if you post a simple banner, even if it's not the best banner, it's better to have that banner than none. And it can be only one data subject. If there is a complaint filed to the supervising authority, the consequences can be exactly the same in case of a big or small company. So the companies that choose to do so, they are showing very short-sighted approach to the whole policy, not only around data protection, but around the organization itself. It is something that Sarah described in a very elaborate way.
As Anna described, it's kind of, I would call it, that they're negligent, and and generally customers or suppliers or employees will hesitate to do business with companies who they feel are negligent.
Lastly, because we went over the time, I will request anyone that attended, if they have any questions, they can always email us at info@seersco.com, and we will try to answer it. We will ask that question to Anna and she'll be able to reply to you guys. Anyone that's attended, we will be more than happy to offer you discount on any of our compliance solutions. So if you feel like you want to try any of our solutions, just feel free to give us a message.